You know what's an overused word these days with the Trump administration in court? Scathing, stinging, fiery. These are all words that are used to describe how judges are firing back at the Trump administration. And we have the latest one. I don't want you to get fatigued about it because it's important. Judge Xinis in Maryland, who's the judge who's supervising and administering the justice as it relates to Abrego Garcia, trying to get him back from El Salvador for his lawless capture and removal and deportation. She just used those words among other choice words. Listen, I've been doing this for 35 years in federal courts, and I've never been on the receiving end, nor have I really seen my opponent be on the receiving end of an order that used words like accusing the other side or charging the other side with willful disregard of discovery obligations, evasion of fundamental discovery obligations, using specious arguments raised not in good faith in a willful and bad faith attempt to stonewall the court. And according to Judge Xinis, it ends now. This was all about the discovery, which is the exchange of information before hearing or trial. It takes a few formats: depositions, question and answers under oath, like you're in a courtroom, interrogatories, written questions and answers under oath, and requests for production, which is what it sounds like. You get documents produced to you. You need that in order to develop a proper record before a trial or a hearing. In this case, the other side, because of Donald Trump, the Trump administration's willful failure to do anything to facilitate the return of Abrego Garcia, despite a 9-0 Supreme Court ruling that tells them they have to, two different panels of the Fourth Circuit Court of Appeals telling them exactly that, and Judge Xinis telling them that on at least 4 or 5 separate occasions. They refuse to do it. Not only do they refuse to do it, they mock the Trump administration, mocks the court, mocks, this is my mock universal symbol, mocks the Supreme Court, mocks the federal courts. We'll never bring him back, they wrote in a social media post that looked like it was written by a 4th grader. They do this whole circus, a clown car filled with 14 clowns at the Oval Office. I'll show a picture here with President Bukele there. They got everybody all excited. Oh, President Bukele's coming. Maybe that's a good opportunity for Donald Trump to ask for Abrego Garcia's release from the prison that the U.S. put him in. Oh, no, I would never, Bukele said, wearing his black T-shirt with a suit jacket on top of it, like, I don't know what. He said, oh, never, I would never smuggle a terrorist into the United States. And Donald Trump, I would never ask him to do that. It's a man's life is at risk. It could be killed at any moment. Thank God, Senator Van Hollen. You know, there's a lot of different things going on all around the same time. As I begin to read you this scathing order of Judge Xinis from yesterday, throwing the book at the Trump administration and giving them till later today to fix it. It ends now, she says. No more slow footing, slow walking, bad faith, contumacious conduct. She's trying to figure out whether she should hold them in contempt. I know a lot of people are saying, we see it. Throw the book at them. It's time for contempt, whatever that is. But judges they're strange creatures. They like to have things like a full record and evidence and documents and testimony, so their decision can be supported at the appellate court level. So that's what she's doing. She's in the process of doing it. You think, knowing that they're staring down the barrel of a contempt order, you'd think that the Trump administration would go out of their way to mind their P's and Q's. No, this Trump administration is out of its mind. They're pushing this to the extreme. Now, look, I'm going to do a separate hot take about how I see them. There might be a sea change approach to Donald Trump about Abrego Garcia, because his campaign against the family, trying to tar them as, wife beaters, human traffickers, definitely MS-13 because he owns a Chicago Bulls jersey, whatever the arguments are, is not working. You've got Republicans and Democrats on both sides of the aisle saying it was you got John Kennedy in Louisiana, the senator, saying it was a classic screw up. This is deep stupid. Why are they bringing him back? And Van Hollen saying it's lawless. They need to bring him back from the deep, dark jail cells of El Salvador. So that's the backdrop, right? The tar and feathering of the family's not working for the Trump administration. Their ridiculous juvenile mocking of the, we'll never return him. Van Hollen, you're a fool. That's not working. And he's getting hit with terrible, terrible rulings by the Fourth Circuit Court of Appeals, including Judge Wilkinson, the Supreme Court 9-0, which he needs desperately to do anything in his crazy policies. He needs 5 votes at the Supreme Court. So he just figured out how to count. Oh, I need 5? I only have 4 reliable. I need another one. Yeah, well, maybe stop jerking around with court orders. And and he knows also, I think they were shaken by this 1 a.m. ruling that came out on Saturday. This all goes into the mix now. They're in front of the judge yesterday on why aren't you complying with your discovery responsibilities and turning over documents and information to the heart of the case. Let me read to you from the order. You'll see where this is going very, very quickly. First, they raised an objection to everything, saying all the requests are based on a false premise that we have an obligation to release Abrego Garcia or seek his release from the prisons of El Salvador. Yeah, that's because that's exactly what the United States Supreme Court said. But she used more choice words. Here's what Judge Xinis said. Defendants object to certain discovery because they claim the requests are based on the false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. She says defendants and their counsel. She makes a point of reminding the lawyers, your liberty, your ticket to being a lawyer is in my hands. Defendants and their counsel well know that the falsehood lies not in any supposed premise, but in their continued mischaracterization of the Supreme Court's order. The order made clear that this court properly required the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been if he was not improperly, or as she said, lawlessly sent to El Salvador. She says almost all the objections raised by the Trump administration are willful and in bad faith refusal of their obligations. She then struck them. At the end of the day, she said by today, Wednesday, at 6 o'clock, they need to fix all their answers, provide all their documents, and then she'll hold for now in abeyance what she's going to do about their prior sanctions. Let's continue. She says about their privilege assertions, because sometimes when you don't want to produce documents or information, you raise a privilege, like attorney-client privilege or state secrets privilege or executive privilege. But you have to, under the federal rules, you have to lay out the facts that support the privilege. And if you're putting documents and you're withholding them, you have to put them on a privilege log, which is a list of the documents by type and by description sufficient enough for a court to figure out what the document's about without revealing the privilege or blowing the privilege. But they didn't do that. They just said privilege, boilerplate, privilege. The judge is like, that's not going to work. Defendants invoke in name only a range of protections: attorney-client privilege, work product privilege, deliberative process privilege, state secrets privilege, and an undefined governmental privilege without providing any supporting information or analysis. As defendants and their counsel know, the proponent of a privilege must demonstrate the legal and factual basis to invoke it, and they have not done so. Instead, she says on page 3, defendants and counsel, she always is warning the counsel, defendants and counsel stubbornly refuse to provide any basis for the same. Thus, she finds that it was not asserted in good faith. Nor, she says in the bottom of page 3, nor does the court find defendants' protestations regarding the abbreviated timeline persuasive. Like they're crying about, we don't have enough time. For weeks, the judge said, defendants have sought refuge behind vague and unsubstantiated assertions of privilege, using them as a shield to obstruct discovery and evade compliance. Yet they have continued to rely on boilerplate assertions despite the fact that they've had at least a week. That ends now. If you want to preserve their privilege, you got to support it with detail. You have till 6 o'clock tonight to do it, or I'm going to strike your privileges. She also says that on the reading about the timeline, she says you have to give documents about his lawless seizure. She calls it lawless seizure, and his transport and confinement to CONTEMPT in El Salvador, period. She says about other objections, the information regarding Abrego Garcia's removal, this is on page 4, as well as placement and confinement in CONTEMPT, cut to the heart of the inquiry. Namely, what steps, if any, defendants have taken or will take to facilitate Abrego Garcia's release from custody in El Salvador and ensure that this case is handled as it would have been had he not been improperly sent to El Salvador. She also finds the fact that they only gave the name, they had to provide the names for all the people who were involved with ordering or authorizing Abrego Garcia's removal to El Salvador, his initial placement in CONTEMPT, and his continued confinement there. And they threw two guys under the bus, just two. Robert Cerna, acting field officer, director of a processing center, and Evan Katz, assistant director of enforcement and removal. She's like, that's impossible. But those were the only two people involved in all of this. These are the scapegoats. By the way, Mr. Katz and Mr. Cerna, start looking for jobs now, because you are not going to last there. You will be fired by the Trump administration, especially if this turns against you, which it already has. This is what the court says on that. Defendants have failed to respond in good faith, and their refusal to do so can only be viewed as willful and intentional noncompliance. Contempt, here we come. Defendants may supplement their answer to include all individuals involved. You have until 6 o'clock tonight. Now, what's going to happen? Everybody always wants to know that. Here's what's going to happen. They're not going to properly amend their answers. They're going to provide half of what they're required to provide. The other side, led by a very good law firm, Quinn Emanuel and the ACLU, are going to file another motion for sanctions. The judge is going to award it. She's going to start fining them $10,000 or $100,000 a day. She's going to find them in default, the Trump administration. She's going to order more depositions. Already one was taken. She's going to order more depositions under oath. She may sit in on the depositions herself. And then she's going to move to a contempt hearing. And at the rate she's being affirmed and validated by her appellate bosses, I would not. Meet me on camera one, Trump administration. Stop effing with Judge Xinis. You picked the wrong. First of all, there's no federal judge to pick on, but you picked the wrong federal judge with Judge Xinis. Two different panels of the Fourth Circuit have affirmed her rulings. That's 6-0. And 9-0 at the United States Supreme Court. You didn't even get Thomas or Alito. You don't get Thomas or Alito, and now you're losing Republican support for your position. Your campaign to try to tear down the family and make this guy out to be MS-13 with ridiculous comments is not working. And the polling is showing that the Democrats have surged ahead of the Republicans for who people want to see in charge of Congress. Let alone people, 58%, the polls and CNN say, want to see Donald Trump impeached and removed if he continues to not obey federal court orders and the Supreme Court. I think you should stop struggling. It's not working. What was that thing we had when we were kids? Chinese finger cuffs. You stuck your fingers in on each side. Your friend would say, here, put your 2 fingers in here. You'd be like, oh, okay. And then the more you struggled, the more you couldn't get out of it. That's what's going on here. They're in finger cuffs. Stop struggling. Start complying. It ends now. I'm Michael Popok. You're in Legal AF. You know what doesn't end? Our drive to continue to grow our subscriber base. Hit the subscribe button right now. The reason we're doing it, just so you know, it's not just like I like numbers. I like numbers. It's because the bigger we get, the more your voice is heard. It signals to everybody how important this content is here. You get reminders of our content. We're doing about a dozen a day. And I'm able then to leverage all of that whole ecosystem, to bring on some amazing new voices here onto Legal AF, which I think you're going to find really, really amazing. I got one I'm going to announce next week. Not ready yet. 2 amazing people. Just fantastic that they called us to be on Legal AF, if you will. I'll continue to bring on great people. You do your part. Hit the subscribe button, and we'll do this together. We'll build this channel together. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. States and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.